Hello, everyone. So, a warm welcome to our talk on Section 230. I'm Kyle Malati, and we'll be talking about how a bunch of old white men in the 90s wrote a bunch of words on paper, and now all of us have to follow it or face the consequences. Now, this particular group of words laid out specific provisions for how websites should be treated when people produce content on those sites. It's a very important law. So Section 230 was passed in 1996 in response to a few lawsuits and court cases, especially Stratton Oakmont versus Prodigy Serves Co., which moderated some posts and was found liable for all of them. So a law got passed to say that websites cannot be found liable for most posts because they are not to be treated like publishers. They are not responsible for what you post. Since we have long evolved from the internet's early days, Section 230 has led to some very dangerous legal and ethical situations. We split up liability of Section 230 cases using this analytical framework to study how corporations can be found legally liable for actions despite their Section 230 protections. Surprisingly, they can be found liable a lot. So first we ask, what is the ethical role of websites? Well, some people say the websites are publishers, or at least they are responsible for what got posted. For example, if they promote, manipulate, and or profit off your post, they should not get immunity. Other people think that ethically, it wasn't the company's actions, but rather their lack of action or their supplemental action to a third party that holds them liable. From the technical side, websites are required to comply with privacy laws, antitrust laws, third-party transaction laws, harassment, cyberbullying, etc. This means some degree of moderating has to happen on those platforms, since despite their Section 230, they have to employ algorithms, real-life moderators, or a combination of both to ensure no violation takes place.
So the first topic relating to accusations of direct liability is algorithms promoting content. These accusations are about anything having to do with how companies automatically show users content, products, or results to queries. The biggest cases almost always involve social media sites, search engines, and online vendors. Judges actually ruled on 3 similar cases about terror attacks in Paris, Istanbul, and San Bernardino. All 3 were victims against Google, Facebook, and Twitter. They say algorithms recommended videos to watch and people to follow, and that since the recommendations are created by the companies, they should be held liable. Cases have been denied previously because reasons used were protected under 230. For example, a man bought heroin from a message board and died, but the site was not actively promoting it. In another terrorist attack, they had a passive and neutral algorithms, which they ruled can't be held liable. The Istanbul case is the only one to be revived because the plaintiff argued that approving monetization was knowingly sharing revenue with terrorist groups. However, all 3 judges did agree that Section 230 needs to be changed, and the beginnings of a new bill to place responsibility on companies that use algorithms to promote content has already been started.
Consistent with its intent to foster the growth of the internet, when Congress first drafted Section 230, it specifically exempted intellectual property law, as robust IP rights are crucial for the internet's success. This means that computer service providers are still liable for intellectual property violations posted on their platforms and must comply with DMC regulations or be held responsible. In 2001, a web hosting company, Mindspring, hosted a site that violated Gucci's trademark. After requesting that it be taken down multiple times, Gucci sued Mindspring for trademark infringement. Despite this type of content usually falling under Section 230 protections, because of the IP exemption, courts still held Mindspring responsible for the violation and upheld the lawsuit. This pattern is consistent among other cases, but one area of disagreement is whether the same logic applies to state laws or only to federal IP law, as some states have extended IP protections past federal law. The Ninth Circuit held that it did not apply to state law, holding that the service provider CC Bill was immune from a right of publicity lawsuit brought by Perfect 10 under state law. However, recently, the Third Circuit disagreed. In a similar case, the Third Circuit found that Facebook was liable to state law right of publicity suits brought in response to content posted on its site. Here, the court found that the IP exception did include state laws, and thus Section 230 protections did not apply, and the service provider was still liable for infringing content posted by others.
As you may know, Snapchat released a speed filter in 2013 that displayed how fast a person was traveling when they took pictures. Filters are graphic overlays used to modify pictures users take. Over the years, many teenagers wanting to capture high speeds used the filter while driving recklessly. This tragically caused multiple fatal car accidents, and the filter was ultimately removed in 2021. Various people sued Snapchat and argued it was negligent in creating the filter in the first place. The theory advanced was product liability, similar to what happens following recalls of defective merchandise. The linchpin of Section 230 provides immunity to websites serving as publishers of content created by others. There's a misconception that the law provides blanket immunity to websites, but that's not true. Websites can be held liable for content that they create themselves. In Lemon versus Snap, Inc., the Ninth Circuit Court of Appeals in San Francisco sided with parents of one set of teenagers who died while attempting a speed record. The court held that since the filter was Snap's own creation, Section 230 did not protect the company from the parents' products liability lawsuit.
Another example of Section 230 being applied is in the court case Goddard versus Google. Goddard, on behalf of all others similarly situated, claimed to have been harmed by clicking third-party ads of fraudulent mobile subscriptions when searching for things on Google. Goddard sued Google for facilitating the distribution of these fraudulent ads. She argued that Google was an accomplice since they had a keyword tool that suggested words for advertisers to include in ads. For example, advertisements about ringtones had better results by including free. In other words, free ringtones reach more people on Google than ringtones. This jurisdiction fell under CDA 230, Google argued, which stated that the websites aren't treated as the publishers or speakers of third-party content. In other words, content providers are not reliable for what users post, excluding content related to federal crimes and intellectual property law. Since it didn't fit these requirements, the Ninth Circuit ruled in favor of Google.